Welcome to our webinar. My name is Jean Reisz. I am a clinical professor of law at the University of Southern California Law School, and I co-direct the USC Immigration Clinic. I'm very excited for this panel. It's timely, and we have some great experts in the field here who are going to talk about some of the impacts of the current Trump administration's major aggressive enforcement agenda. So just to give you an overview, I'll introduce myself. We'll have opening remarks from our esteemed speakers and a moderated discussion, and then there'll be time for question and answer afterwards. So submit your questions, please, if you have some that you would like to be addressed by our speakers. One of the things that we'll be talking about today is, I teach immigration law, legal ethics, and appellate law. And one of the kind of basic immigration law tenets are the president can't pass new immigration laws, can't change immigration laws, but has so much power over immigration law and the way it's enforced. And we're really seeing a presidential administration going all the way to the limits here regarding kind of the way enforcing law is changing law, up to reinterpreting the 14th Amendment citizenship clause. So some of the biggest ways that this administration is really reducing the ability for people to lawfully migrate to the U.S. through refugee and asylum is through travel bans, pause on the U.S. refugee admissions program, declaring, through all these executive orders, declaring an invasion and halting asylum processing at the border, which was recently found to be unlawful by the D.C. Circuit in Reisz v. Nome by violating our U.S. immigration law, which will probably be appealed to the Supreme Court. We have other tools of enforcement, terminating TPS designations for thousands of people, tens of thousands of people, halting the adjudication of existing asylum applications for people from different countries, re-scrutinizing asylum applications, considering removal of certain refugees who have not yet applied for lawful permanent residence. We have a robust denaturalization unit under this administration. And then we have our kind of mass roving patrols and sweeps that we're seeing, which is being a tool of immigration enforcement that's going hand in hand with new detention policies. We're co-counsel on the Maldonado Bautista case that challenges this new interpretation of the law to apply to require mandatory detention, meaning no bond hearings for people who've been in the U.S. for longer than 2 years. Currently, as of April, there's over 60,000 people in detention, and over 70% of them have no criminal convictions, and many are being denied bond under this new policy. We're seeing no use of humanitarian parole, or use very sparingly. I can't tell you how many clients that I have who are in custody in hospitals because they have significant health concerns and they aren't being released on humanitarian parole. We'll be talking about kind of this new reinterpretation. There's circuit splits right now between siding with the government or finding that these new interpretations are unlawful. Our speakers will talk about that. And then even if you are, if exercising non-citizens exercising the right to challenge their removal, to apply for particular immigration relief, we still have due process challenges. Immigration judges who have not signed on to the enforcement agenda have been fired. We are seeing pretermission of asylum applications, third country removals, and judges denying bond if one gets a bond hearing based on flight risk for things that are linked to their status in the U.S. So we have lots to discuss, and I just wanted to give a preview, but I'm going to turn it over now to our speakers to introduce themselves give a few opening remarks, and I'll start with Courtney McCausland.
Thank you, Jean. Welcome, everyone. Thank you for joining us today. My name is Courtney McCausland, and I am a managing attorney here at the International Rescue Committee. I have been in practice in immigration law for about 8 years now, and about 6 of those years I spent doing almost exclusively removal defense representation of individuals largely seeking asylum in the immigration courts and some ancillary procedures as well, but at the trial level up through the appellate level, mostly based here in the San Francisco Bay Area. And as an attorney who started practice under Trump 1, I sort of cut my teeth under this particular posture that we find ourselves in now. And so in some ways, it kind of feels like this pacing is how I learned to practice law, but in other ways, we are seeing some things play out under Trump 2.0 that I think just so far exceed what we ever saw happen under Trump 1. And there are really 2 takeaways that I hope everyone will glean from our conversation, at least from my contributions to the conversation today, which is first that the American immigration system has always been adversarial. It's always been adversarial, but it is now in chaos. And the second point I hope you will take is that the dismantling of all pretense of checks and balances behind the scenes that is happening under the auspices of policy and procedure is so much worse and so much more insidious than most people realize unless you are an active practitioner in this area, which for me really it recalls the idea of the banality of evil, of what we see playing out in just the everyday small administrative decisions that are being made. So for context, 693 new immigration policies have been issued just in Trump 2.0. And much of that directly plays into this political theater that is being performed on both a domestic and international stage. And there are long-term implications for this for us, both domestically and internationally. But crucially, I would say, is the effective undermining of the rule of law, because what we are seeing play out is the creation of a precedent of non-precedents. So we've created a culture where no directives can be relied upon because they are changing every single day. So it's really undermining people's confidence and ability to effectively navigate a system that was never really designed to be effectively navigated in the first place. And so while immigration enforcement is this topic that's being covered more in the media, and in many ways for good cause, right? Like there are many liberty interests at stake for citizens and non-citizens alike when we have a paramilitary force that's effectively conducting operations on the streets of America without oversight and with impunity whenever they violate the law. But one of my sort of core things that I feel drawn back to repeatedly under this administration is that the real insidious threat that we are dealing with here is this dual prong approach of both dismantling and weaponizing the administrative state. And that's something that I hope we'll get to expound upon a little bit more.
Yes, thank you so much. Thank you. And so now we'll hear from Olga Byrne. If you could introduce yourself a little bit and tell us a little bit about some of your opening remarks here.
Sure. Good morning, everyone, or good afternoon if we have anybody on the East Coast. Really appreciate you inviting me. I'm Olga Byrne, the Senior Director of Asylum and Legal Protection at the IRC, along with Courtney. And I support our programs in the U.S. and in Europe that provide legal and humanitarian services to refugees and immigrants. The first thing I want to say in this context, and as Courtney was getting into, it's truly an unprecedented time in the U.S. It's also happening in the context of many other countries tightening their migration and refugee policies. We have several program operations in 6 countries in Europe where the EU Pact on Asylum and Migration is about to go into force now in June. And that's going to result in increased detention, expedited asylum adjudications that will surely risk denying protection to some people who really need it, and increasing capacity for returns, cutting off admissions programs. European countries never had as much resettlement as the US did, but they had various types of humanitarian admission programs. Germany just ended theirs for Afghans, leaving thousands of people stuck in Pakistan. So familiar story to many of you who have followed what's happened to Afghans who had been promised a pathway to the US. And we often find ourselves in these exchanges, European colleagues saying, discussing how much worse the situation is getting, the risks to human rights, the human rights violations in countries that really also have a dialogue of human rights. And then you'll hear the US colleagues saying, well, at least you still have X protection, or at least you still have this. And it's become kind of I don't know, like a what could be worse. And you really feel people, obviously those who are directly impacted, but also the ones who serve them, in a state of deepening despair as we see an erosion and erosion and erosion of rights, while at the same time constant fighting back on those rights. And you're going to hear more about that, I think, especially from Courtney. I think the last thing I want to say, before we get into it, is that maybe there is still some hope, even in this unprecedented time that is really damaging so many people's lives and their families' lives. I think, for one, in the midterms, some of us do have hope that a little bit of a shift in the dynamics in Congress could put some more accountability on this administration. I mentioned, that we're seeing a worsening of policies in countries outside of the US. Every once in a while, we do come across a continuing welcoming policy. And just to put out a quick anecdote, we were able to collaborate with a program in Brazil where they still have a welcoming policy. They still have expanding admission programs for Afghans, for people from other nationalities. We were able to get one Afghan family who had been denied admission to Germany and was stuck in Pakistan, admission to Brazil. It's only one family, but in times like this, it really truly feels like a success and gives you a little bit of hope for the future. And finally, we saw during Trump 1.0 some efforts to rebuild, to form, to organize better, to form more coalitions, and we're seeing that now as well. It's a tougher environment, but to some extent, can we expect, and I hope that we can expect, a better rebuilding after we get out of this administration? Thank you.
Thank you. So I appreciate that hope, because sometimes I forget about the fact that maybe things can get better, not worse. And next, we'll hear from our speaker, Manuel Orozco. Please introduce yourself, and we'd love to hear kind of your thoughts about this topic.
I think hope is about seizing the opportunity to be ready to continue the fight. I'm the director of Migration, Remittances, and Development Program at the Inter-American Dialogue here in Washington, D.C. I've been working on these issues of migration, the determinants of migration, the interaction with immigration policy, and the impact of remittances to developing countries, particularly to Latin America. And indeed, this approach of expulsion and exclusion, it's unique. My 30 plus years doing this work, it is definitely one of the most unaccountable approaches, and with the more devastating consequences for everyone. Particularly, there are increasing vulnerabilities that are emerging for the Latin American countries, but also even for the U.S. economy. I mean, when we look at Latin America, the flow of deportations, close to 500,000 last year, accompanied by the declining migration, especially labor migration, which is 1/10 of what it was in the past previous. years. And the decline in the number of remittance senders has had an effect on the flow of money going to Latin America. And this is particularly important given the fact that the income dependence on remittances is significantly large. And yet it has a positive effect on the issue of migration. The people who receive remittances and formalize their savings from this flow of money are less likely to migrate. And what these politics are doing is actually going in the opposite direction, because it's creating anxiety on people. The deportations of people include individuals who have lived at least an average of 5 years, those who lost their status on the temporary protected status are people who have been for 20 to 30 years in the United States. So the impact is significant. You also not only are dealing with the issue of the vulnerabilities in the homelands, but also many of those who are deported are people who are at risk of their lives. And there are many former political prisoners who have been deported to countries like Nicaragua and are facing persecution all over again. There is very little remedy for this. The immigration authorities really disregard the background of the individual who had an asylum process moving forward, and they were just simply trumped by it. There's also the economic consequences for the U.S. are significant, and one way to look at it is in terms of migrants themselves. The fear among migrants have produced a number of dynamics. One of them is that they try to send more money to their relatives in case they are deported, but they are using their savings to do so. So that is affecting their financial and economic condition. But the other issue is that because of the persecutive approach to deportation, to immigration rates, many migrants actually have shifted from holding full-time jobs to keeping temporary variable jobs. So in a survey we did in September 2025, close to 60% of migrants had a stable job. We repeated the same survey in February, March 2026, and the percentage dropped to 37. And that reflects really the politics of fear, that you try to stay in more than one place in order to avoid being detected. And this is happening at a time when there is still a demand for foreign labor. The demand is significant, and we can see it, for example, in the continuous demand of H-2A and H-2B visas. And it begs to see, for example, you have deported 500,000 people. This year, the deportation numbers will likely be the same, and yet the unemployment rate continues to grow because it's growing in sectors that are independent and apart from those workers that were in construction or in the service industry. So the consequences are really significant in not only Latin American countries, but also in the United States.
Thank you. And you talk, about this politics of fear that really is destabilizing here in the U.S. as well. So I'm going to, switch a little bit here. Courtney McCausland, you had talked about this unprecedented as the norm and weaponizing the administration. And in the context of detention, we've seen that under this big, beautiful bill, there's been, so much money earmarked to the construction of new detention facilities. And I see that as part of that weaponization and this kind of new interpretation of mandatory detention. Could you speak a little bit about kind of what these policies are that have expanded, who is denied bond hearings if they are detained by Department of Homeland Security, by ICE, and what are some of the arguments being used, the unprecedented arguments perhaps being used? Could you speak a little bit on that?
Yeah, absolutely. It's a complex sort of web of arguments that are being raised around mandatory detention. And so I think it can be useful to start with kind of a framing of a concept of how did we even arrive to a place where we have a system where we can mandatorily detain people administratively. So just kind of level setting with that, we have this idea that holding people in detention ensures better attendance at hearings, and it provides for increased public safety and border security and the effective execution of removal orders. And all of these have been sort of addressed and also, I think rebutted is the word that I'm reaching for, but it's that those are not the only considerations at play. And so but that has been addressed and rebutted by everyone from the United Nations to the American Pediatrics Association, right? We've got all of these stakeholders who have chimed in and said this shouldn't be happening. But there's a couple of things around mandatory detention. So there's basically three different statutory provisions under the Immigration and Nationality Act that are used to justify detaining someone under these mandatory provisions. The first is there are certain criminal grounds, and that was expanded in January 2025 under the Lake and Riley Act. So we've seen movement on this in Congress as well, not just from the executive branch. But then where this really does get expanded the most aggressively is through the policies of implementation being put in place by this administration. And so ICE has in particular taken an extremely expansive understanding of who qualifies under each of these provisions. And getting into the sort of nitty gritty of that is perhaps beyond the scope of what we have time to get into today. Suffice it to say, it is a brand new argument and it is being actively litigated in court because they are effectively arguing that anyone who has entered the United States without inspection is, quote, seeking admission and is subject to mandatory detention at any time. So it creates this incredibly arbitrary standard. And instead of sort of reckoning with the arbitrary nature of that standard, this administration has sort of doubled down and said, no, it applies to everyone. We will be detaining and deporting everyone. And that, again, sort of ties back to the political theater piece that I was mentioning earlier. But one of the things that I think is also really fascinating here is that in other litigation contexts, we have a very robust understanding of prosecutorial discretion, that it falls to the government to decide which cases they want to spend the resources to actually prosecute. And that has effectively been eliminated here. They have taken this approach that this applies to everyone. We will be prosecuting everyone, which speaks to the point that you raised earlier, Jean, which is that we now have over 60,000 people currently in immigration detention. And that's, not even inclusive of the people who have already been removed. Mm-hmm. But I think the real rub for all of this for me is that when we start talking about mandatory detention and bond hearings, it kind of jumps the shark a little bit because those barriers really are just adding insult to injury. They're excluding the very few people who even made it far enough along in their case to get to the point where this particular provision is applying to them. So we have this legal fiction in immigration where there is no entitlement to legal representation because these are civil proceedings and not criminal proceedings. And so the way that this has been, we have constitutional entitlement to representation in criminal proceedings under Gideon v. Wainwright has not at this point been extended into administrative civil immigration proceedings because administrative detention is not punitive. So it's considered that we don't have the same liberty interests at stake. But with all of that, we have this legal fiction that you're not entitled to counsel, and something like 70% of people who have been removed from the United States never had access to counsel. And yet we also know that if you have access to counsel, you are more than 5 times more likely to be successful in your proceedings. And so there's even just this threshold issue of, are people being given access to counsel? Do they have the resources to meaningfully engage in this system before we even get to a question of whether or not they are being screened out by all of these administrative decisions that are happening? So it feels farcical at some point, because as a matter of practice, the majority of people don't ever even get to engage with these very high level administrative questions. But for those who do, for those who make it far enough along, what we are seeing be successful are these constitutional due process challenges, particularly the filing of habeas petitions in federal court. Because broadly speaking, you put these ridiculous cases in front of a federal judge and they're like, we can't justify this. And so they grant the habeas petition, you get in front of the immigration judge, and then you have a much better chance of actually receiving bond and getting out of detention. But again, that also presumes you have access to an attorney to file this habeas petition for you, because this is not something the average person has the skills or resources to do on their own.
Mm-hmm. And I think, historically, too, immigration attorneys, you bring up how hard it is to get access to counsel. And then historically, I don't think the vast majority of immigration attorneys did habeas litigation in federal court. In the Central District, I think in 2025, they had about 24 habeas petitions. And in 2026, I think in the first 2 months, they had about 600. And they're on track to have over 3,000 by the end of the year. So as you pointing out, the habeas is pretty vital to challenging these due process. What other kinds of one of the things, I'm a little blurry. One of the things about these detention policies, which I think, you've touched upon, is the conditions, the limited access to counsel. How is that helping this enforcement agenda? And then for those people who may have the ability to seek relief, as you say, if they get far enough along to be able to seek asylum, for example, are there other policies that are reshaping kind of how people are able to actually, if they get far enough to be able to seek asylum and be successful?
Yeah, there certainly have been shifts in that way, in terms of what is happening in the actual adjudication of cases. I think, again, not to just be a broken record about this, but a lot of it does just come back to like policy and procedure and how it's being implemented. So, for example, what we have seen en masse for the last series of months have been these large-scale pre-termissions of asylum application cases under the asylum cooperative agreements. So sort of tying us back into our international policy sphere. But what was really interesting about these is that these asylum cooperative agreements were extremely short. Like, I don't know if anyone here has actually taken a look at them, but they were just like a couple pages. They're not detailed. The number of people that were actually approved to be accepted into these third countries under these agreements was extremely small. And yet this administration was applying these cases, or 2 cases en masse. And so almost immediately, the number of people whose cases were being dismissed or pre-termitted under this exceeded the number of people that those countries had ever legally agreed to even take. So that has left this huge group of people just in limbo, because their cases, they either appealed that decision and now we're sitting, for appeal at a very hostile Board of Immigration Appeals, or their cases were outright dismissed, and yet the government doesn't have the authority to remove them to these third countries because there's no one available to accept them. Or then, the sort of third alternative, non-alternative, is removing them to their country of origins, which if they were asylum seekers, violates the principle of non-refoulement. So it's just every single step, it becomes more ridiculous and self-defeating. And all of this really ties into a much larger issue than we have time to get into today, but the fact that we don't have an independent immigration judiciary. The fact that our judiciary sits in the executive branch means that judges are implementing these decisions, arguably in contravention of circuit court law, because that is what they have been directed to do by the executive branch. So there's just barrier on barrier on barrier with all of this.
Yeah. Olga, I wanted to ask you kind of what are some of the most immediate legal risks facing immigrants already living in the U.S. Under this Trump 2.0 agenda?
Yeah, so they're massive. There are too many to name, but I'll go into sort of two I guess two groupings of risk, and they both relate to actually, ironically, not violating the law or getting something wrong in the process, but they both relate to really doing everything right, but then still finding yourself up against a system that's trying to pull you back and potentially send you back to your country. So first, going to ICE check-ins or immigration court hearings. Most people who are in the U.S. as asylum seekers, or at least many of them, are following two different processes. So one, they're pursuing their immigration court case, their asylum case in immigration court, and then they're often also under supervision of ICE and the Department of Homeland Security, which is, tasked with making sure they still live at their address. They are going to do ongoing criminal background checks and whatnot, and often require them to come for various supervision check-ins. Arguably, there was always some risk in going to an ICE check-in under any administration that the person could be detained. But that has really shifted under this administration, to the point where, we see clients who are saying, what am I better off doing? I haven't done anything wrong. I've done everything I'm supposed to do, but I don't want to leave my daughter, without a parent. I don't want to be flown away in the middle of the night. And so they're really left with an impossible choice. And in response to that, you've seen a lot of agencies, for one, lawyers wanting to accompany their clients to, if they weren't doing that already, to their check-ins. And then also kind of an expansion, or at least attempts to expand, like volunteer accompaniment programs, just making sure that people have some kind of, safe, trusted adult with them who can push the red alert button if something happens. Immigration court is the other place. And that's where we've seen really unprecedented actions in terms of ICE in courtrooms and making arrests. Now, to Courtney's point earlier about what really are the justifications for immigration detention, and the argument was always compliance. People might not attend their court hearing, or they might not, continue with other requirements, including departure from the country if required. But now you've got ICE in courtrooms. I'm based in New York, and we started to see this really, really accelerate in a harmful way in 2025, where people are going to their court hearings, doing everything they're supposed to do. And then as soon as they walk away, as soon as they finish that, that initial hearing with the judge, ICE is there waiting to pick them up. We had a client who, upon walking out, said a little prayer like this before opening the door, and then unfortunately, ICE was there waiting to arrest him and detain him. And then, this goes back to Courtney's remarks earlier about habeas responses to that. USCIS. So these are the three components sorry, I'm getting a little confused here. The second component of DHS, not ICE, USCIS is your adjudication agency. It's meant to, help people naturalize, help people get their spouse to join them in the US, help people access immigration benefits that are available to them under the law. Under this current administration, and in a way that's much more expansive than we saw under Trump 1.0, USCIS is being weaponized as an enforcement agency, as an agency that, showing up to your USCIS interview could result in your arrest and detention. So quickly, I'll talk about two policies that have had a profound effect on IRC's clients in the U.S. One is what we call the refugee re-interview policy that was issued right around Thanksgiving, November 21st. This policy requires USCIS to review the cases of all refugees who were resettled effectively under the Biden administration, from January 21st, 2021 until February 2025. That's 233,000 people. They are the group of non-citizens who are most deeply vetted, over usually a period of a few years before they're allowed to enter the US. But nevertheless, this administration is putting resources into that. And at the same time, the policy says we're going to put a pause on green card adjudications. Refugees are legally required to apply for their green card to adjust status after being in the US for 1 year. So you've also got people now in this, again, in like a kind of legal limbo of like, I'm trying to follow the process, but I can't because there's this policy that is, putting up some kind of barrier or obstacle. A couple of weeks after that, December 2nd, another policy, like sweeping policy memo came out in similar fashion, calling for a review and a revetting of previously approved immigration applications, as well as a pause on all future adjudications for a group of people. In this situation, it is individuals who come from the quote unquote high risk countries or the travel ban countries, which is a list that's actually 39 countries now. It includes many countries in crisis. People have come there, or come to the US from these places as refugees, as people with other humanitarian protection needs, and are now caught up in this limbo. What the immediate effect that we saw among our clients was within days of this policy being issued, immediate interview cancellations because there's a pause on adjudications. We had in the first week of December, we had already 100 clients that had reported interview cancellations. We had, and we have not seen as much, and we don't have time to get into this really yet, but we think the revetting is yet to come. We have not seen as massive sort of high scale revetting and sort of the results of that revetting and re-adjudication. What we have seen at scale is the cancellations, the pause, and the mental health impact that has on our clients. So an Afghan woman who went to her interview in early December, she hadn't gotten a notice yet, gets there. The officer says, "No, I'm sorry, ma'am, your interview's canceled. I have no further information." And our colleague saw our client just completely break down in tears ever since she had seen news come out about, policies that we're going to be reviewing Afghan and other cases. She has been, having sleepless nights, up all night, struggling to take care of her children. And this is what we're hearing from all of our clients, really, really across the board. And the last thing that, sorry, go ahead.
Can I interrupt you just to ask,
Yeah.
how long had she had to wait even to get that interview that was eventually canceled?
In this case, she was an asylee. So she had come through Operation Allies Welcome. She had humanitarian parole. She then successfully applied for asylum and was granted asylum. So also like getting, vetted every step along the way. And had then reached the 1 year mark. So was able to apply for her green card. So I don't have the exact amount, but she had been, and she's also rebuilt her life in the US. So there's the risk of going back. There's everything that's been built here. There's the connections. There's work, and there's all those broader impacts on the community. So I think what I would say is some of these risks we have seen, albeit not at this sort of level of aggression, but in the past, asylum seekers have faced an impossible system for a long time. And as Courtney was saying, a highly adversarial system. What is totally unprecedented now is that the same level or increased level of attacks is being made on people who have come through US invited pathways. regular pathways who are already like well along, not just granted protection, but have been here with protection, with status, in some case for years, and are seeing that ripped out from under them.
Yeah, if I may interrupt,
Mhm.
let me give you the example of the 222 political prisoners released or incarcerated from Nicaragua in 2023. They all started under humanitarian parole, and then they were supposed to reach the adjustment of status applying for asylum. The majority of them have not received hearings, and some of them even received letters, even though they were political prisoners, with deportation notices. And I mean, the level of due process, it's just beyond outrageous. It's pervasive. It's really damaging for everyone.
Mhm. And the justifications, right, have been the worst of the worst. We're going to keep this safe. We have this invasion, and we're going after people who are lawfully,
Well,
migrating.
there is not just, I mean, there is not even justification anymore. Look at the Supreme Court debate over temporary protected status for Haitian and Syrians. I mean, they basically say, it doesn't matter what the argument is.
Mm-hmm. Yeah. So let me ask you, Manuel, the kind of the stricter U.S. policies, are they changing migration routes? Are they increasing irregular migration elsewhere? How is this impacting people's decisions?
I think the immediate response is no, there is no change, but that's because migration was slowing down since 2023. And a lot of it was because of the demographic trend. So many people have left their home countries between 2029 and 2024 because of political conditions. I mean, the 12 million arrivals at the border between 21 and 24 came from 19 countries, all politically difficult countries: Russia, Ukraine, Guatemala, Honduras, El Salvador, Nicaragua, Cuba, Haiti, Venezuela. They're politically complicated countries. They all were escaping repression, but the sheer number of people that left had a demographic impact on the labor force in the homelands. And that put pressure on those who stayed to basically postpone any decision to migrate. When we look at the numbers today, the intention to migrate has not changed. The intention to migrate in 2024 ranged from 20 to 15% in Latin America of households with an intention to migrate. We repeat that process this year in last March, and the numbers are pretty much the same. So the root causes of the problem have not been addressed. People are still thinking of leaving their home countries because of the problems they're faced, with a potential and likely decrease of remittances next year. And even by the end of this year, this will be accentuated. So there is no change in routes, but there is a holding pattern at this point. There's also Cuba, Haiti, Nicaragua, and Venezuela. Each of these countries' political crises have had different momentums that have reduced the mass outflow of people. Venezuela, the political crisis with the removal of Maduro, created some sort of an illusion of opportunity to return. In Cuba, there is no possibility to migrate at this point. I mean, it's truly fucked up. In Haiti, you also have basically borders closed in the Dominican Republic and in the United States, and the ability to move to Canada has always been limited. And then Nicaragua, The effect of the humanitarian parole actually worked in reducing migration, but the level of repression continues. So the likelihood of people trying to leave their home countries next year, it's going to be significantly large. In the survey we did in March, there is a strong correlation between the intention to migrate and those who returned this year. And I mean, this is not the first rodeo we dealt with deportations. People who have been more than 7 years in the U.S. and are deported, the first thing they do is try to return. And not because it's cool to come back, it's because you have financial obligations here. And you have family obligations too. And that makes it hard for you to just stay in a country that you have been disconnected with for a long time. So this is the current condition. People are not going to Costa Rica or not going to Colombia or Peru or Chile. I agree with Olga that this is not only a U.S. Trend, but the extent, the magnitude of this is not an anti-immigration sentiment. This is a politics of exclusion and expulsion, similar to experiences that have been very few to compare with pogroms and the like. And we have to confront this problem face on, because it's not. This is going to have devastating consequences all along, not only for the U.S. but the international community.
Could you speak a little bit about those consequences? And for those of you viewing, please feel free to enter into the questions, and we'll have a question and answer session. But Manuel, can you talk a little bit about some of those consequences?
Well, let me put it this way. Close to 40% of international migration comes from 44 countries, all dictatorships. Migration is driven by political repression and economic deprivation. And economic deprivation is tied to political conditions, the lack of democracy. And we have seen basically in the past 15 years a huge democratic backsliding, to the extent to which we have all this network of dictatorships, many of them, or most of them, if not all, with very strong relations with Russia and China. This is not pamphletarian talk. This is the fact. The economic dependence of this dictatorship with China, for example, is really strong. It's stronger than trade with the United States, for example. The foreign indebtedness of these countries is huge relative to all international borrowing from developing countries. So the consequences of this is that if we continue to have this type of, it's not just strict policies, it's just expelling people and containing them at the same time, we're going to run out of allies that will be able to help you to fight these authoritarian and these totalitarian regimes. And those have consequences for the U.S. national interest. I mean, let me give you another example. Russia just established military relationships with Nicaragua, where it's allowing the Russian regime to set up military bases in Nicaragua to take over the Nicaraguan army to direct new strategy on national security. Now, this is a threat to the U.S. Nicaragua had already altered the military balance with Central America, importing weapons from Russia, equivalent to 3 times the military budget of El Salvador, Guatemala, and Honduras. So we are really challenging. Then you have China. China is increasing its presence. The political model, the Chinese political model is devastating. By any means, because it's not democratic, it allows for police market economies, but with huge restrictions And it gives the impression that it's cool to do business in China, but when you take a closer look with labor rights violations and human rights violations, this model is not viable for the modern society. Yet, the relationship these countries are having with these dictatorships having with China are increasing. And this is a real problem. So, I mean, when you run out of allies, then who are you going to rely on to fight these dictatorships?
Yeah, yeah, it's terrifying. So, we will open it up to questions. I'd like everybody to, feel free to submit your questions. But in the meantime, I have a question for all the panelists here is, do you think that there's the possibility of reform? We talked about, is there hope? And is there a way to prevent these devastating consequences that Manuel talked about? Or, I guess we're so polarized. Is there any fix here? So I open it up to anyone.
I think right now, no. The debate is highly polarized. The piece of legislation introduced by Manuel Salazar, for example, the Dignity Act, is a good piece to work with. It's not one that I entirely agree with, but the component on regularizing a number of migrants in irregular status is somewhat decent. And it's not something that you should throw out. Yet, the principal opponents to it are not Democrats, are Republicans, who are there against it, even though public opinion is pretty much going up against ICE and against these restrictive immigration policies.
We do, unless anybody had more thoughts on that, we do have a question. How do you see the court system being impacted with the new judges taking the bench?
Well, maybe I can jump in on this one. I think this question is an interesting one. It's also a very live question. And I think it also depends very much on which bench we're talking about. So we have seen, it's well documented at this point, there has been a several decades long campaign to staff both federal and state court benches with more conservative justices. And so as those lifetime appointments have taken effect, we are seeing increasingly conservative case law emerge from those benches. And so that's something that is going to have generational effect. And that's just true. But then when we're also specifically speaking about the immigration judges and the new judges who are being appointed to the bench, this one I think is very interesting because we have seen this huge retaliatory backlash in staffing on the immigration bench. And in fact, the entire closure of immigration courts that were seen as being too respondent friendly. Just a few days ago at the start of May, we saw the closure of the main San Francisco immigration court, which was largely seen to be this retaliatory response. And there's been a couple of different approaches by this administration to staff those positions. And one was this movement to staff them with folks who were JAG. And it turned out the military was not on board with this. The military actually really objected to having their people placed on active duty doing someone else's job. So they were not even on board with this. And then what also happened was these JAG attorneys who did not have a background in immigration came in, started adjudicating cases, and started granting them at rates that this administration did not like. So they very quickly axed that program. So I think it's interesting. I think it's a live question because I can also just speak from my own experience that I've had immigration judges who came through the sort of JAG to ICE attorney to immigration judge pipeline who took from their experience that like the rule of law matters and the government should be held to a standard. And I've had great success in front of those judges who really uphold the rule of law. And I have likewise had judges from the private bench come in and I think have a very harsh view of their colleagues bringing cases forward. And so I don't generally like to give like broad characterizations of what we are going to see, but I do think for immigration judges, much like the hiring of asylum officers at USCIS, there's a different profile that's being sought in candidates right now, right? And so it used to be that the people who were hired to adjudicate asylum applications were former Peace Corps volunteers, and then they started hiring folks who had backgrounds in military interrogation, and that's a qualitatively different interview to receive. And I think we're going to see the same thing on the bench as well.
So we got another question about kind of what would be the reasonable case that is made on part of conservatives who favor more restrictive immigration policies. I'm happy to answer this. I think that when we're talking about enforcing immigration laws, we're under an administration that's not enforcing the laws, because as Olga pointed out, you're pausing refugees, you're arresting people who are complying at court, who are going to their check-ins, you're finding ways to circumvent the immigration laws, as the DC Circuit Court showed in Reisz v. Nome, that by expelling people under INA 212F at the border, there isn't an invasion and you are circumventing congressional intent who created asylum laws to be enforced. So I think that we're seeing not just trying to find people who are present in the country who are in violation of civil law, but applying these aggressive approaches that are, many times not enforcing the laws because they're circumventing them. Well, we are two minutes at the end. I don't know if anyone had so I have a final question. This is a good one. What can we do as public to help make a difference for someone like the woman that Olga mentioned, the Afghan woman that Olga mentioned?
I'll come in. I love the question. I think, if you have time, look for volunteer accompaniment programs in your community. None of us can we can't change this administration single-handedly or stop necessarily everything that's happening. But I think accompanying people, especially as members of the community, to say, we appreciate your being part of this community, and I think that can make a difference.
Yeah, I agree. I think there is a moral obligation to look into these issues and inform yourself better and find organizations to volunteer. But the other one I think is really important. It's like we have to educate ourselves what justice means. What has it meant in the United States, the due process of law, and what fairness has implied in the past 4 decades at least, and compare and contrast why these changes are really detrimental to individual civil rights. We need to really go back to basics, but I think we lost a clear understanding of the justice system and justice itself.
Thank you. Well, thank you so much to our panelists for sharing. There's a lot to unpack in a short period of time, but thanks for educating us. And thank you all for joining us.